Please be seated. The court is now in session. As scheduled, today the Chamber will hear the testimony of the civil party TCCP 188. Mr. Evidentiary, could you report the attendance of the parties and individuals to the proceeding? Evidentiary, Mr. President, all parties to this case are present, except the accused Ieng Sari, who is present in the holding cell downstairs due to his health reason. The civil party who will testify today, that is TCCP 188, is present and awaiting to be called by the Chamber. As for the reserved civil party, that is TCCP 108, is available. Thank you. President, thank you. Today, as decided by the trial chamber in the document dated 26 November 2012, that Ieng Sari can participate in the proceeding from the holding cell downstairs pursuant to Internal Rule 81.5, that is for the benefit of fair justice. And yesterday, through his defense counsel, Mr. Ieng Sari withdrew his waiver to be present in the courtroom and instead to follow the proceeding from the holding cell, in particular during the hearing of the testimony of civil parties. However, this morning, before the commencement of the hearing, Chia Kun TV, the treating doctor, of the accused at the ECCC detention facility, examined the health of Mr. Ieng Sari, and that found that he is easily fatigued due to slight movement. He has trouble with his chest, and that he could not eat much, and that he vomits. He also made a recommendation that Mr. Ieng Sari cannot participate directly in the courtroom, and that he should be allowed to follow the proceeding from the holding cell downstairs so that the doctor can monitor his health. For that reason, and based on the request, and that he is required to exercise his right if it is not consistent with the existing rules and procedure. The chamber ordered the accused to follow the proceeding from the holding cell downstairs through audio-visual means. Defense counsel, you may proceed.
Thank you, Mr. President. Good morning, Your Honors, and good morning to everyone in and around the courtroom. First, there was a wrong translation, so let me, at least it came out in English that way, so let me make very clear our position. Yesterday, Mr. Ing Sari filed a withdrawal of his waivers and is insisting on being present in court and not participating indirectly downstairs in the holding cell. So there was a mistranslation. I want to make sure that everybody fully understands the position. Along with the withdrawal of the waivers, a notice was also filed where we indicated what the law is on this issue. Today we did meet with Mr. Ing Sari and we spoke with the doctor. And we will be asking that the doctor come and give evidence. Because we asked the doctor, is Mr. Ing Sari capable of following the proceedings all day long, as was indicated to us by Dr. Campbell? And he laughed. I was with my case manager. I leave it to you to interpret what the laughter meant. But when we look at this rule, 81.5, it says, where due to health reasons or other serious concerns, the accused cannot attend in person before the chamber, but is otherwise physically and mentally fit to participate. And there is the crux of the problem. That's the rub of our argument, is the but. Otherwise physically and mentally fit. And we have maintained that he is not mentally fit because he's unable to concentrate. Now, if the trial chamber will insist on him being downstairs, we have a couple of choices. One, we have the monitor on him at all times so everybody, including his lawyers and the public, can see exactly his state of affairs. We do not wish to participate in a proceeding where our client is downstairs, he's fatigued, he's asleep, he's semi-conscious, and yet we're pretending that he's actually following the proceedings and he's assisting in his own defense. We, on the part of the defense, do not wish to participate in this sort of an enterprise. The other option is to bring him into court, which is exactly what Mr. Ing Sari wishes. Now, I can understand the trial chamber not wishing to have the public view Mr. Ing Sari, or for there to be a record of his actual state of affairs. So the other option is for one member of the defense team to be down there to be videotaping him. Because one way or the other, no matter what, we will be making a record. That's what we tried to do when we made a request to the trial chamber that you issue an order at the detention unit so that we can monitor how he is. And instead, you held a secret meeting without the defense, but included the prosecution. And that meeting had to do with something totally different. We were not invited at the meeting where you had a conversation with the prosecution, DSS, the administration about the facilities. We had made a request that he be allowed, the caretaker be allowed to either tape record what she was able to observe, or to have somebody at the detention unit write down what she observed because she's illiterate. And you took that request and then went on to hold a secret meeting. And I use the word secret because the defense was never invited. And so for these reasons, we think that before we go on, we hear from the doctor. And I intend to question the doctor. I want to make a record. We want a complete record. We understand the trial chamber's dilemma. Finishing the trial while Mr. Ieng Sary is still alive. I understand that. My function is to make sure that he gets a fair trial. And he cannot get a fair trial. He cannot exercise his rights if he's down there, semi-conscious, in pain. He can't concentrate. He can hardly breathe. And we're pretending that he's actually participating in the events. It's a charade. So my request, first and foremost, is to have the doctor come. We will then see what the trial chamber does. We've already discussed the matter with Mr. Ieng Sary, and if necessary, we're prepared to walk out of this courtroom because we certainly do not wish to substantially contribute to this affair unless his rights are fully and fairly protected and we make a record at all times as to his actual state of being. Thank you.
Thank you, counsel. The floor is now given to the prosecution to respond to what has been said by Ieng Sary's defense. You may proceed.
I'm on my feet.
President, the floor is now given first to the prosecution to respond to what has been said by the defense team. Defense counsel, please be seated. You will be given the floor later before we commence the hearing of the testimony of the civil party. Of course, we noticed that you were on your feet, but we will deal with the issue of Mr. Ieng Sary first, as his defense counsel stood on his feet and made certain remarks, and the floor is then given to the other side to respond to what has been raised by Ieng Sary's defense. And let me deal with that issue first. The prosecution, you may proceed.
Thank you, Mr. President. Good morning, counsel. Your Honour, firstly, in relation to the defence application that the accused be brought into the courtroom, as your Honours have correctly noticed or observed, in your decision on the 26th of November, you noted that Professor Campbell stated that Mr. Ieng Sary would be more comfortable in the holding cell. More comfortable because the holding cell has a bed as opposed to a chair in the courtroom. More comfortable as he has quicker access to bathroom facilities, and his care will be more greatly looked after if a doctor was present with Mr. Ieng Sary. And certainly, I think it's not the submission of the defence that bringing Mr. Ieng Sary into the courtroom would make his conditions more comfortable for him. And certainly, I think it would, by bringing him into the courtroom, it would just actually make his health condition more difficult because of the accommodations that Professor Campbell said that should be in place for him. So it would not be the right thing to do that. But the fundamental issue which Defence Counsel rightly discusses in a sense is whether or not Mr. Ieng Sary has the ability to follow the proceedings substantially. And it's not a question of whether he follows the proceedings in the courtroom or in the holding cell. It's just largely it's the question as whether or not he can substantially follow the proceedings through audio-visual means as allowed for under Rule 81.5. That's the key issue. Your Honours have heard expert evidence on this matter, and that's what your decision refers to. There have been 3 experts in the last 3 months that have examined Mr Yangsari, and they have all said that he's mentally fit and physically fit, despite being frail, to participate in this trial, whether it be in the courtroom or in the holding cell. And their recommendation was that it would be in the holding cell. It's normal to expect that someone of that age needs extra facilities to assist with his health condition. But one thing is clear, is that your decision has been made on the basis that he could fully and meaningfully participate at trial. And what occurs often, we hear at the bar table from the defence one state of affairs, and then in their pleadings we hear another state of affairs, and in the evidence we hear another state of affairs. Nothing that counsel has put forward today is really consistent with the evidence that you have heard, and Your Honours must base your findings on evidence, not on party submissions. In fact, when we look at the request for reconsideration, which all the parties received yesterday, asking Your Honours to reconsider the decision, I quote at paragraph 32, where the defence for Yangsari state, "There has never been any allegation that Mr Yangsari is mentally ill. This is simply not the issue." So they're certainly not claiming that he's mentally can't follow the proceedings. And if you look at paragraph 31, contrary to what was put forward today, that was written yesterday, it states, "If Mr Yangsari does not lie perfectly still during the entirety of each trial session, but instead turns his head slightly, shifts his position, or must get up, he will not be able to concentrate." But certainly this is very consistent, what the Yangsari defence are putting forward, with the assessment of the doctors, that if Mr Yangsari does lie still, doesn't move around, and is put under the best and the most optimum conditions, which would be in the holding cell, he can follow the proceedings for an hour and a half and then have a break, and then he can follow the next session. That's what the doctor said, Dr Campbell said. Dr Campbell said he interviewed him for an hour and a half in November, and he was able to follow the conversation, and he came back in the afternoon and interviewed him again, and he was still able to follow the conversation. And that, in fact, is what Yangsari has put forward in their own pleading yesterday, that if he does lie still, he can follow the proceedings, and certainly in the courtroom wouldn't be the appropriate place at this point in time, certainly based on what Professor Campbell said and what the doctor said this morning. As to this issue of the Yangsari defence, speaking to the doctor and the doctor laughing, it's really unclear what that amounts to. I assume that Your Honours have received enough information on the doctor to be able to conclude that he would be able to follow the proceedings from the holding cell today. And certainly that's a prerequisite or a fundamental in Rule 81.5, that the accused be able to follow the proceedings, whether it's in the courtroom or in the holding cell. So all we would ask, the prosecution would ask, is that Your Honours satisfy your minds that the doctor today has provided enough information for you to conclude that he's able to follow the proceedings today. Then obviously the trial should continue today. And as long as Your Honours have received that information, we would submit, based on the evidence that you received so far from the doctors, that that would be enough to continue today's hearing. You know, the prosecution has always said that Mr. Yang Sari's health is fragile, and the doctors have said that as well. But it must be looked at on a day-by-day basis, and certainly as long as Your Honours are happy, are confident that you have enough information that he can follow the proceedings for the day from the holding cell, it is in the interest of justice that whether Yang Sari gives a waiver or not, that the proceedings continue, because his presence in the holding cell is in fact a virtual presence before the court, because he has access to his lawyers, he has access to the hearing, he's got counsel defending him. That's the international standard, and that's the standard under Rule 81.5. So as long as Your Honours can assure yourself that the doctor has given enough information to say he can follow from the holding cell today, we would submit that the hearing continue today. Thank you.
Thank you. Now the floor is given to the lead co-lawyers for civil parties. You may proceed.
Thank you, Mr. President, and good morning to you, sir. Good morning to the bench and to the courtroom. Very briefly, to add to what has been said by the prosecutor, my first point concerns the change in Yang Sari's position yesterday, because suddenly he's decided no longer to waive his right to be present. The participants and the witnesses are the same, and yet suddenly Yang Sari has decided that he wishes to be present, while hitherto he had renounced that right. So I think the first thing we should do is ask why there has been a U-turn in his position in a trial of this kind. My second point that I would like to make, as the prosecutor has said, and I would like this to be expressed from the civil parties as well, that on the 26th of November last, the Chamber, taking account of all concerns and taking account of the rights of Mr. Yang Sari, the Chamber provided for special arrangements, and I believe that is totally in keeping with international case law in this area. I think it's perfectly normal for the Chamber to have made this decision after hearing the experts who gave us an overview of the situation, and I think it's very clear that Mr. Yang Sari is able. It has never been said that he was half unconscious, as the defence seems to be saying today, and I think that therefore we can abide by the decision taken by the Chamber. We've heard the view of the doctor. We don't need to hear it once again in the courtroom. The Chamber has taken due account of that, and I believe therefore that we can continue our discussions as things stand. It is in the interest of the civil parties that the discussion and debates be continued to their conclusion. Thank you.
The President, International Counsel for Mr. Yang Sari, you may now proceed.
Thank you, Mr. President. Just let me hit a couple other points that were made. First of all, Mr. Smith misstates and misleads the trial chamber when they claim what our position is. We have never stated that Mr. Yang Sari is mentally ill in the sense that he has dementia. What we have claimed is that because of his physical illnesses, he's unable to follow the proceedings. That has been our position. It has been consistent, and we don't know why the prosecution continuously tries to mislead the trial chamber into believing otherwise. They say it's a day-to-day situation. I agree. In fact, we would say it's an hour-to-hour or moment-to-moment situation. When Dr. Campbell was here, that was weeks ago. Part of the reports that he relied on by the other doctors was months ago. What is he today? How is Mr. Yang Sari feeling today? When I asked the doctor and he laughs, that was enough for me, but we can hear from the doctor. That's what's most important. Because the fundamental issue here is, how do we monitor? And how do his lawyers monitor? Because the lawyers are there to protect the client's interest. I don't rely on the trial chamber. I'm sorry. As a defense lawyer, I've always maintained that it is counsel's duty and responsibility to protect their client's rights. So how do we monitor from moment to moment, hour to hour, day to day, whether our client is capable and indeed able to follow the proceedings? It is not sufficient to say he's downstairs, he's in the presence of the building, we have a television monitor there, and therefore he is present and he's following the proceedings. That is insufficient. It's like me on my couch, asleep with a television on. I'm not watching what's on the television. Am I present in the living room? Yes. But that's what we're talking about. And we have maintained that because of his physical illnesses, he is unable to follow the proceedings. And we met with him. We're the only one in this room, by the way, unless the doctor's here, who's actually met with Mr. Ingsuri. We actually have seen him and talked to him to see what his condition is. Whether Mr. Ingsuri takes a U-turn or not, it matters not. The Constitution doesn't say, well, you only have one time and one time only to exercise your rights. It's a continuing right. And if the trial chamber is going to insist that our client 24/7 is capable of assisting his defense, then we are insisting, and the client is insisting, that we monitor the situation in a way that you can actually see it. If he's in a courtroom, and if he's asleep, then you can see that he's unable to follow the proceedings. So then I can make my application that based on 81.5, he is not physically or mentally able to participate. That's what this is all about. And what the prosecution would like is to just have him in the building. It doesn't matter whether he's able to participate, but let's try to finish this case, get the conviction, and be done with. That's what this is all about. Now, we either give him his rights or don't give him his rights. We can't have it both ways. So if you don't want him physically present, then you have capabilities so that there's a video cam on him at all times so we can see him, the public can see him. The alternative is for us to be down there and to be videotaping him so we have a record. Otherwise, we're being accused by the prosecution of giving evidence. But that's what has to happen. Otherwise, it is a trial in absentia. That's what it amounts to. It is a trial in absentia. Being physically present isn't enough. And so we would ask at this point that the doctor come, because contrary to what the prosecution claims today, and again, another misleading and mischaracterization of the doctor's pithy report, the doctor never made an assessment as to whether the client is capable of following the proceedings throughout the day. He merely states that it is more comfortable for him to be down there. Comfort is one thing. Capability of following the proceedings is something else. And so the doctor never made that assessment, and we don't even know whether the doctor is capable of making that assessment. We don't know whether he has the expertise, but he certainly can give us a medical opinion as to his state of affairs and whether he is, in fact, able to follow the proceedings throughout the day with the breaks that we have. Thank you.
The President, next, the Chamber would like to hand over to counsel for Mr. Noon Chia because he appears to have something to say.
Thank you, Mr. President. Good morning, everyone. First of all, I'd just like to say what I tried to say.
The President. Counsel for Mr. Noon Chia, if you have something to say relevant to the health condition of Mr. Ieng Sary, you are allowed to do so in the ambit of internal rule, subparagraph 5 of Rule 81 only.
Thank you, Mr. President. Again, good morning, everyone. I have nothing to say about the health of Ieng Sary. I simply, as he's not my client, I simply wanted to support the submissions that were made by our colleague, Mr. Carnavas. The larger issue of active participation, effective participation in these proceedings, obviously is an issue that affects everyone. And as I've said before, I personally do not think that this court should be in the business of keeping up appearances. We really, really ought to look at the reality of the situation. If somebody is not able to participate, as Mr. Carnavas has very clearly stated, that person has rights. Those rights need to be defended and protected, and that's all I have to say about that. Are you going to be making a ruling on this issue now? Because I do have some other comments about other issues.
The President, thank you, Counsel. Indeed, we have to rule on this before we proceed to another issue. The Chamber is seized of this matter and we have to rule upon it immediately. So the bench would retire for 30 minutes so that we deliberate on the issue raised by counsel for Mr. Ieng Sary concerning the health condition of him. The court will adjourn until 10 past 10.
សូមអញ្ជើញក្រោកឈរ